appeal in the matter of B.
Yes.
Good morning, my lords. I appear for the appellant in this matter, the appellant father, assisted by Mr. Edwards of counsel behind me, and Magistrate Assistant Mr. Hull, and associate from the office appear behind him. My own friend Mr. Gupta, King's Counsel, appears for the respondent mother, assisted by Ms. Kumar and Ms. Campbell Brunton, also behind him. And for the court's information, the mother is sitting at the back of the court. My lords, I hope you've had, in advance of this hearing, electronic bundle of the appeal bundle, an authorities bundle, and a separate transcript of Dr. Ratnam's oral evidence to the court in August. I'm grateful. Lord, I think at the bar we're working from electronic copies,
Right.
but we'll try and assist us in relation to the hard copies, which you also. Can I mention two matters at the outset? Firstly, I don't think I'm going to be longer than an hour in oral submissions, and Mr. Gupta likewise seeks not to be longer than an hour in his submissions, and perhaps no more than 10 minutes in any reply.
Right.
So we hope to be completed by lunchtime today. You also will have seen from the judgment in the appeal bundle the name Tara, which appears throughout the judgment. My lords, that appeared because the learned judge, in her wisdom, decided that she was going to import a fictional name into her
Right,
judgment.
okay, that's what I was rather assumed.
When the draft came out, counsel indicated that probably wasn't a great idea and we should use S, which is what we will use.
Yes.
But it appears that that hasn't been remedied within the judgment. And that's
Has
why.
it been published or not? I don't know.
No, I don't think
It hasn't. Right, okay.
The Lord will also have noticed the typographical error in our skeleton argument, paragraph 3 on page 22, where we asked permission to set aside the return order.
Yes.
Of course, there is no return order.
No.
We invite the court to make a return order, or if not, to remit the matter for further hearing. So, my lords, in relation to the background, that's set out at page 22, which is B2 of your appeal bundle, sets out the background to the father's 1980 Hague application, and you're concerned with S, who is now 17 months of age. The parties met in Australia in 2021, but never married. The mother's a British national, as you know, and the father's an Australian national. But the mother has dual citizenship, having lived in Australia since 2013. S was born in July of 2023, and in September of 2023 it was the intention of the parties to come to England for an extended holiday to visit the maternal family. And you'll have read that the father's application for a visa was refused by reason of his criminal conviction in 2006, and therefore the mother travelled alone with S to England for a period of about 5 weeks. On the 6th of November she returned to Australia, and on return, between then and December, the parties' relationship deteriorated to the extent that the father had agreed to move out of their shared accommodation on the basis the mother would take over the rent herself and she would continue to work. At the beginning of December, the mother indicated she was going to go and stay with a friend, and by the 2nd of December, indicated to the father that in fact that she had travelled to England with S and didn't seek to return. The father, in turn, then issued his 1980 Hague application on the 12th of April 2024, and that's at page 92 electronically, and the matter was defended by the mother on the basis of Article 13 only. So, Lords, perhaps a useful starting point is to look at the authorities bundle, and in particular the 1980 Hague Convention, which you find at page 1 of your authorities bundle. My Lord Moylan will, of course, be very familiar with the Hague Convention. My Lordship perhaps less familiar, but Article 12 is the mandatory article which provides that the authority of the contracting state must return the child to the jurisdiction of origin unless one of the defences is made out. And Article 13 in particular is over the page 2.
Yes.
Notwithstanding the provisions of the preceding article, Article 13b, the institution or other body which opposes return will not do so if there is a grave risk that his or her return would expose the child to physical or psychological harm, or otherwise place the child in an intolerable situation. Now, in relation to that, my lords, can I direct you then to page 78 of the electronic bundle, sorry, page 82 of the electronic bundle, 78 of the hard bundle, and that's the Supreme Court decision of Re E, and in particular the judgment of Baroness Hale, and the requisite test for Article 13b set out at page 97, electronically 93 of the hard copy, at the bottom of that page from paragraph 29 onwards. Article 13b is repeated, and paragraph 30, reference is made to Re D and the judgment of Lord Justice Thorpe as to the ambit and purpose of Article 13b. The authorities of the requested state are not to conduct their own investigation and evaluation of what is best for the child. There is a particular risk that the expansive application of Article 13b, which focuses on the situation.
Where are you at the moment?
This is the middle of paragraph 30.
Okay.
The quote from Re D. Particular
Yes.
risk that an expansive application of Article 13b, which focuses on the situation of the child, could lead to this result. Nonetheless, there must be circumstances in which a summary return would be so inimical to the interests of the particular child that it would be also contrary to the object of convention. Then we get to the requisite test and the threshold for the purpose of Article 13b from paragraph 32 onwards. Paragraph 32 deals with the burden of proof and in terms the ordinary balance of probabilities. And then paragraph 33, the most important aspect as far as this appeal is concerned. The risk to the child must be grave. It's not enough, as in other contexts, such as asylum, that the risk be real. It must have reached a level of seriousness as to be characterised as grave. Although grave characterises the risk rather than harm, there is in ordinary language a link between the two. Thus, a relatively low risk, death, or really serious injury might probably be properly be qualified as grave, while a high level of risk might be required for other less serious forms of harm. Over the page, paragraph 34 is the well-known quotation in relation to intolerability. Strong word, but when applied to a child must mean a situation which this particular child in these particular circumstances should not be expected to tolerate. And then finally, for the purpose of our argument, paragraph 35, Article 13b is looking to the future. And so, of course, in assessing the defence at the time of trial, looks to the reality on the ground in the return state at that date. So, my lords, that is then further set out in the case of Re IG, which is in your bundle at page 325 electronically, 321 hard copy. Where the other Lord Justice Baker makes reference at page 337, 341 electronically to the relevant principles which are summarised at paragraph 47. And there's nothing in
Sorry,
that.
hold on. Which paragraph?
Paragraph 47, page 337. And in emphasising those principles, subparagraph 2, the focus is on the child. The issue is the risk to the child in the event of his or her return. Subparagraph 4, when the allegations on which the objecting parent relies to establish grave risk are disputed, the court should first establish whether, if they are true, there would be a grave risk to that child would be exposed to physical or psychological harm, or otherwise placed in an intolerable situation. Over the page at paragraph 48, Lord Justice Baker also referred to my Lord's judgment in Re A, my Lord Justice Moylan in Re A, paragraph 48, emphasising the approach in which the trial judge should evaluate the risk and evaluate Article 13b. And in terms, if the court does not follow the approach above, it would create an inevitable prospect of the court's evaluation falling between two stools. The court's process of reasoning, to adopt the expression used by Lord Wilson in Re S, paragraph 22, would not include either considering the risks to the child or children if the allegations are true, nor B, confidently discounting the possibility that the allegations gave rise to an Article 13b risk. The court would rather, by adopting something of a middle course, be likely to be distracted from considering the second element of the Re-E approach. And I'll come back to that in due course, but that, we say, is important in the context of this appeal, because we respectfully say the trial judge did indeed fall between two stools in failing to evaluate the risk in the first instance, and secondly, then failed to evaluate the mitigating aspects of the protective measures which provided for the return of the child to Australia.
There's a slightly, it's a middle way as well. I mean, in 47.6, they're asking whether the allegations are sufficiently detailed to give rise to the risk, but they're assuming that if they're detailed, there is a risk and they don't investigate them. And then you ask if they can be ruled out. But this is a slightly different case because the question in part may be whether or not you can determine not whether the allegations are true, but rather if there is a return to Australia, a removal of support under deterioration,
Yes.
what then would happen to the child?
Indeed, indeed. And as I'll come on to, we submitted to the trial judge that there was a degree of speculation about that, and she in part accepted that. But in evaluating mental health in this context, my Lord's absolutely right, the court has to assess on the ground whether the protective measures would enable a return, or whether in those circumstances, despite protective measures, there would be a grave risk to the child, not to the parent, a grave risk to the child, that they would be at risk of harm in those circumstances. So my Lord's absolutely right. One has to evaluate and take the context of Dr. Ratnam's evidence, in particular psychiatric evidence.
Yes, we're not. This case is not within the sort of conventional framework, because it's not taking allegations at their highest. It's an assessment or evaluation, in particular, of the effect of the expert evidence.
Yes, indeed.
And what conclusions can properly be reached on the basis of that evidence, and obviously the other evidence.
Yes. And the mother did make a raft of allegations against the father, but the reality was that those were ameliorated in any event by the protective measures offered by the father. And there's no suggestion that the mother wouldn't be living independently and caring for us upon any return. So,
and there's two stages. What will happen to the mother if she had to return? And then, if that happened to the mother, what would be the impact on the child? Because things could happen to the mother and things might be tough. But
indeed.
will that stop the mother being a good mother?
Indeed. And it's the test, in my respectful submission, is whether the mother would be so psychologically disabled as to not be able to care for the child. And in those circumstances, whether that amounts to a grave risk of harm to the child, or whether the reality is, as my Lord said, it would be very tough for the mother, but that wouldn't necessarily lead to her psychological dysfunction and inability to care for S in those circumstances. And as we've made clear in our Skousen argument, there was not one iota of evidence that this mother was in any way psychologically impacted in her care of S. In fact, Dr. Ratnam made clear that her care of S was at all times appropriate, and she was able to discharge her parenting functions without difficulty. So, my lords have, of course, Dr. Ratnam's report in the bundle. That's at page 435, electronically in the appeal bundle. And that report was dated the 14th.
Hold on. You're not. Are you taking us to any other authorities or not?
My lord, I don't seek to take you to other authorities at this juncture.
Okay.
We don't have RE-A in the bundle, but I think in light of our reliance on that, we'll submit that to you in due course, because it is important in the context of the evaluation. We say that this
Sorry, excuse me.
we say it's important in terms of the evaluation. We say this judge should have carried out.
Right.
My lords, therefore, going back to the appeal bundle, page 435 electronically, which is H331. That's the report of Dr. Ratnam dated the 14th of August 2024, obtained shortly before the final hearing on the 1st of August. And in particular, her opinion and recommendations appear at page 449 of that report, which is H345. And
Sorry, H345.
45.
Thank you.
Models will note the diagnosis.
There was a very small sort of factual question I had in my mind. There was reference in the judgment to an episode in 2019, which appeared to be suggesting that the mother was admitted to hospital. I thought I'd read that she'd gone to A&E, had gone to hospital, but been discharged. As set out in Dr. Ratnam's evidence.
Yeah.
Do you know which it's a very minor detail, but it just puzzled me.
The information of the records is at 339, which details the references and medical references.
It's under 18th November.
Yes.
2019.
She's gone to A&E but was discharged.
Yeah, okay, thank you.
And then going back to 345, that's the diagnosis at paragraph 1, recurrent depression. And then secondly, she fulfilled the criteria for diagnosis of generalised anxiety, symptoms including nausea, difficulty breathing, palpitations and dry mouth and tremor. It notes that she's been abstinent from alcohol since January 2020 and reports being prescribed antidepressants from the age of 16, but those weren't contained in all the medical notes.
Yes.
Importantly, she engaged in, at the bottom of the page, importantly, she engaged in extensive psychological intervention in Australia, which included CBT, acceptance and commitment therapy, and psychotherapy. And over the page, she engaged in further psychology from the 20th of December 23, but of course that was in England by the time she had arrived. And just above paragraph 2, she engaged in SMART, self-management and recovery training intervention to address her alcohol consumption in Australia, also attended AA, and she continues to do so. The protective measures sought by the mother and offered by the father, Dr. Ratnam, commented on at paragraph 8. Access to Medicare, sorry, this is at page 348. Access to Medicare should return to Australia. Need to be able to attend AA meetings regularly, so it's important that she has the means and support to access them. Recommended that handovers of contact facilitated by a third party. And then, again, importantly for the purpose of this appeal, the impact on the mother, paragraph 9. And Dr. Ratnam opines, it's likely that a return to Australia would impact adversely on Miss Renshaw's current and future mental health. She was depressed at the time of the assessment and reported passive suicidal thoughts with expressions of hopelessness should she return to Australia. Whilst adequate treatment in Australia is available, other factors are also important to recovery and maintaining stability. Social support is important in recovery, and although the mother reported she has some friends in Australia, she has a more extensive support system in the UK. Ongoing stress, including relationship discord, will impact adversely on recovery and can also be a trigger for relapse. Over the page, at the top of the page, despite being in recovery, a possibility of the mother consuming alcohol as a coping strategy. And then very importantly, the last paragraph, it is not possible to predict the extent of impact on parenting, but as stated above, depression can impact on the ability to emotionally and physically respond to a child consistently. Now, in light perhaps of the time frame between the report being filed and the hearing, Dr. Ragnam gave oral evidence to the court, and you have, I think, that in a separate file.
Just before going to that, came back to page 346. Another paragraph 4. There is a view at least taken in relation to asked care for the child, isn't there?
Yeah. Yes, my lord. Thank you. Of course, the reported cases make clear that mental health can have an impact on the mother's emotional availability, but the mother in this case denied any difficulties. And as you'll see in a moment,
You have to read over the page too. It appears that she has significant practical support from her mother.
indeed, but nothing approaching, we say, psychological dysfunction to the extent that her ability to parent a child was ever in question.
And that presumably informed the ultimate view which Dr. Ratman came to, which you mentioned at page 349.
And of course, she gave oral evidence about this, and she was cross-examined. Dr. Ratman was cross-examined about these issues within.
Sorry, you're taking us to that.
Yes, that's a 26-page transcript of her evidence. I don't seek to take you to all the aspects, but there are two very important aspects in my view. Firstly, internal page 10. These are questions from the learned judge to Dr. Ragnam between C and D. The first question, which I suspect you've answered in the course of those questions, but I want to have clear in my mind. You were asked questions about vulnerability, and you said that you think this lady is significantly vulnerable. Significantly vulnerable to what, the judge asks? The answer is, well, to further, in terms of mental health, she's vulnerable to current something of depression. And also, when she's depressed at the current time, she's vulnerable to further deterioration of her mental health. The second important question the learned judge asked appears at page 23, internal page 23 of the transcript. And this is in relation to questions that a learned friend asked of Dr. Ragnam in relation to suicidal ideation. And between D and E, the learned judge says this. I think the final answer that you gave Mr. Gupta was about suicidal ideation when depressed.
Where are you?
Between D and E.
Judge Gollop.
Yes, sorry, thank
Judge
you.
Gollop, just pausing there.
Yes.
I think the final answer you gave Mr. Gupta was about suicidal ideation when depressed, and you said that your concern was about a deterioration with no support and the impact on parenting. So can you tell me a little bit more about the future, as you see it, for the child if the mother was asked to return to with the child to Australia? And Dr. Ragnam says in turn, I think it depends on what is put in place for the mother should she return to Australia. If the mother's to return to Australia with her mother as a form of support, that would be limited. The medication is optimised, psychological support, all those are some mitigating factors regarding further deterioration in her mental health. If I can something, it might be that even in those circumstances, she will achieve a full remission from her mental health problem. Given that I think that should be, she won't achieve full remission, given that that's not occurred whilst she's been in this country and there's been ongoing support. But mental health has not affected her ability to respond emotionally to the child. She's not presented as an emotional event trigger. She's been able to pick on the child's issues. At home, the child's emotional and day-to-day needs, albeit with a lot of support regarding practical tasks such as cooking, shopping and washing. My concern would be if and when the mother leaves Australia, and she is in Australia with few friends but little consistent support, from what I could understand, this is a mother who had a long history of mental health difficulties which dates back to her adolescence. So she is vulnerable to relapses. We know that individuals with episodes of depression are vulnerable. The risk of relapse can be between 70 and 90%. So there's a risk of there is a significant risk of deterioration or relapse. In that context, with the ongoing stresses, which might include court proceedings, it will be difficult to avoid the father for sure, because they have a child together and will be an ongoing part of the mother's life. But it needs support structures around her should her mental health deteriorate further, which is likely to happen if she feels isolated and with her past history of depression. Then there's a risk to her becoming emotional about the child and the child's experiences as a mother who is not able to consistently respond to her, and which can affect attachment to the child, although likely the father will be a significant attachment figure. So she will have consistency. But for the child, having a mum who's not always emotionally available or emotionally distressed could impact on her own emotional well-being. So that, with respect to Dr. Ratner, is the highest at which she puts the risk of the mother. There was never any suggestion, firstly, that, as we've explored, the mother was not emotionally available for the child.
Sorry, say that again. Never what?
Never emotionally unavailable for the child.
I think it's never suggested, or never. What did you say? Or never, or
There's
no suggestion.
There's
Sorry,
no suggestion that
thank you.
this mother was anything other than emotionally available for this child.
You underline that at page 25, don't you?
Yes.
That was C.
Yes. And secondly, there was also no suggestion that this child was going to be separated from this mother. And that's important when we come to look at the Joe Contingency course. And it's also important in our respectful submission to look, in fact, at what the mother says about her current circumstances in England. And you find that at page 234 electronically bundle, which is H for Hotel, page 130 of the hard copy. Going back one page, subparagraph time spent in England.
So what page?
This is H129.
And what is this document?
This is the mother's statement of evidence.
Position statement. Or,
Yes,
yeah.
to the hearing.
Yeah.
in
Okay.
court. And it sets out her current circumstances.
Sorry, I'm slightly behind. What page?
Page 129, my Lord, H129.
Yes.
And this is the mother's witness statement in the final hearing in response to the application. Paragraph 108, importantly, we say, child and I currently live with my mother. Last sentence, my mother will occasionally help me care for the child by doing bath and bedtime routines. Over the page, paragraph 111.
I don't understand 109. We visit Stevie's grandma and granddad. That must be great grandmother and grandfather because.
I think that her parents, the mother's parents, are separated.
Oh, right, okay.
So I think it's a different set of grandparents in those
Right,
circumstances.
okay.
Over the page at page 111, the schedule which the mother and indeed the child are subject to on a weekly basis. And you'll just note the amount of different activities, the mother doing exercises, the mother engaging with various play groups and professional groups, but also at paragraph 113, appointment with Women's Domestic Violence Centre doctors, psychologists and AA meetings.
There's a suggestion in the judge's judgment that the mother is not at present able to go out of the house with Stevie, with the child.
Yes.
But that doesn't seem to fit with what's said here.
Plainly wrong. Plainly wrong. And also the degree of support given by the mother on the mother's own account was occasional. And importantly, again, at paragraph 114, the mother emphasises her return to work in April of this year, which we say is again an important aspect of her mental health. So, armed with all that evidence and the reports of Dr. Ratnam, the matter was listed before is Katie Gollop, King's Counsel, sitting as the Deputy High Court Judge on the 21st of August, and her judgment appears at page 77 of the electronic bundle, page F1 of the hard copy. There's no dispute that the learned judge set out the relevant case law appropriately between myself and that. The issue arises when the learned judge looked at the protective measures, and they start at page 82 electronically, page F6, and paragraph 22 in particular.
Sorry, paragraph.
Paragraph 22. The judge recorded the protective measures offered by the father, in particular a lump sum in the figure of 60,000 Australian dollars to be available to the mother in advance of her returning to Australia.
I didn't get it that 60,000 was being offered.
Yes, ma'am. Paragraph 23.
All of it.
Yes.
Because it just says a substantial lump sum. I don't. Is it? So was the whole that sum being offered?
Yes. A substantial lump sum
English
he
pounds
calculates will be sufficient for 6
by
months.
£30,000.
Yes. The entirety of his savings.
Yeah.
And you'll note that he isn't particularly paid handsomely for his work as a pest controller in Australia. But that's what he was making clear to the court, and that's what he said was available. At paragraph 24, the father declined to meet two requests of the mother. Firstly, a separate sum to buy a car, and the cost of a family member's return flight, so that they may support the mother in re-establishing herself in Australia. And my lords, in considering that, can I direct you to page 324 of the bundle, which is the mother's schedule of protective measures. This is at H220.
Sorry, H3.
220.
Wait a minute. H3.
Sorry, H220.
H220. Sorry.
This was a separate document filed by the mother in advance of the final hearing, setting out the schedule of protective measures she would invite the father to consider and make. You'll note that it runs to some 24 separate paragraphs. But in the context of what was being asked for and what was being offered, the father was offering everything except the additional cost of a family member to travel to Australia in circumstances where the mother's parents are independently financially secure and retired, and had in every year travelled to see the mother in Australia at their own expense, and a car which was the subject of an insurance claim in which the mother had been paid 10,000 Australian dollars prior to her departure, and which was to have been used towards securing a second car. In those circumstances, the father said that in any event, the mother would secure property which would be central and available and have available transport links, which would mean the necessity of an immediate use of a car was not necessary.
One of the things that I picked up from the judgment was that if the car had to be bought out of the 60,000, that means there wouldn't be accommodation for 6 months. But looking at the figures very quickly, if it's 3,250 Australian dollars a month, 6 months would be about 19,500. 6 months support at 2,000 would be 12,000. That's still 31,000. There would be 15,000 for the car and other money to spare, or
Yes.
have I?
Yes. Well, my lord, we say on any objective level, the offer by the father was generous, but it was
Cover
clearly
everything.
meant to support, make the soft landing, if I can use that term, the soft landing for the mother and child as soft as possible and supportive as possible, and giving the mother control of that environment, because that money would be paid in advance prior to any return, so the mother could secure her own housing of choice in an area of her own choice as well. We then go back to the judgment at page 82 electronically, page F6. Then the learned judge deals with the expert evidence of Dr. Ratnam, and we pray and aid in particular paragraph 34 at page 8, F8. In response to questions from Mr. Gupta, Dr. Ratnam did not appear concerned that there was a significant risk of alcohol abuse, recurring or repetition of suicidal ideation. Whether it was 4 years into recovery from alcohol dependence and 5 years was considered advanced. The vulnerability remained, but the mother had good insight into her mental health and could identify when she was tempted to have a drink. She would know how to manage those risks. Dr. Ratnam was unable to predict the extent to which the extent of the impact on the mother's parenting of S if her current depression and symptoms deteriorated, save to say that depression can impact on a parent's ability to respond to a child's emotional and physical needs consistently.
It's almost a quote from the ultimate paragraph of the
Indeed,
report.
of the report. But when asked about it further, she said that the impact on S would depend on the availability of support. If the mother returned to Australia with her own mother, medication was optimised, psychotherapy was delivered, the risks that S coming to harm as a result of the mother's impaired mental health would be mitigated. So it's that package of support which is important to mediate the risk. The risk would increase if and when the family support is no longer available. And in the final sentence, when Mr. Jarman reminded Dr. Ratnam there was no evidence that the mother had ever been emotionally unavailable to S, her response was, in this case, the past is no reliable guide to the future. Over the page, paragraphs 37 to 41 encapsulate our submissions to the judge, and essentially that the mother had long-standing depression, treated, medicated, to which she had good insight, and she had always sought and obtained the relevant professional support and psychological support. And in those circumstances, one could not evaluate the risks to the child as grave. The learned judge's analysis and determination then appear at paragraph 48 onwards. which is at page F11 of your bundles. Sorry, F12. And we say that the learned judge fell into error immediately because of paragraph 48. Having not found this an easy decision, I've come to the clear conclusion that the mother has made out the Article 13b defence. There's no analysis as to how that Article 13b defence is made out. There's no analysis as to quantifying the risk, and if the learned judge had found a risk, whether that risk amounted to a grave risk.
That's just a way of, as it were, outlining the approach to the judgment. It goes before setting out my reasons, etc.
Yes, well, my lord, of course I accept that. But then before setting out her reasons in paragraph 49, she says, I agree with many of Mr. Drama's submissions. I agree about the efficiency of efficacy of coping strategies the mother put in place to manage her anxiety. I also agree with his assessment that during the decade she demonstrated considerable independence, drive and resilience, and she functioned at a high level. I agree too that to date she's met all of S's needs and has been not been unavailable to her emotionally. The submission I am unable to accept is that because she has managed her mental health symptoms well in Australia, the possibility if she returns of her not coping to an extent that exposes S to the risk of grave harm can be excluded with confidence. Lords, we say that the learned judge focused and gave too much weight to the situation of the mother rather than focusing on the reality of the child situation in the way that we had directed her to 3E and my learned Lord's judgment in Re A. The other concern is that the learned judge doesn't equate or use the terminology of grave risk. What she says is that the possibility if she returns of her not coping to an extent that exposes S to the risk of grave harm cannot be excluded with confidence. And again, we say that's a misunderstanding and a misrepresentation of the appropriate test.
To be fair to the judge again, that's dealing with your submissions. And at one reading, all she's saying is, I don't accept the argument that because things have been adequate in the past, that they will necessarily be adequate in the future. And what you would then need to do is consider from 50 onwards whether that future assessment was right. She wasn't saying that that's the test. She said saying she didn't accept your submission that you can predict the future from the past. And in fairness to her, she's using this language, which we picked up earlier from Lord Justice Baker's or Mr. Justice's judgment then.
Yeah.
And that's fine if you're starting off with, you assume allegations and you decide if you can confidently exclude them. But our situation is actually a different one that doesn't come within those points.
It's a different one, but it's the same test with respect because we still have to consider whether the risk amounts to a grave risk.
I agree with that, yes,
Whether
but you're not starting off with the
allegations
allegations and saying, can you exclude them?
Indeed.
You've got to look at the facts of the mother and how that will impact on the child.
Indeed. And Dr. Ratnam's evidence, with the greatest respect to the judge, was this is a mother who's had a long-standing issue. She's managed it well in the past. She's accessed the appropriate resources and professional help. And there's a risk because she's vulnerable to previous depression. There's a risk that it will deteriorate. But what the judge never gets to is whether in assessing that risk of her deterioration, that amounts to a grave risk compared to and taking into account the protective measures that would be on the ground in Australia if and when she returned with the child. And of course, the focus being on the child, one has to get to a situation where the risk is so great and so grave that she would be emotionally disabled from caring for the child, which therefore has an impact psychologically and physically in some circumstances on the child. And we say in this case, there is little evidence, no evidence in fact of her being emotionally unavailable. And the evidence of risk is not sufficient to get to the level of grave. And so when we look at paragraph 50, the extent of the effects on S of any deterioration in her mother's mental health must be a matter of speculation, which in my submission to the court, the judge respectfully agrees, is not wholly wrong. But the judge makes the point that S is not a child who's already been exposed to the situation that she will experience upon some return, never lived alone with her in Australia for more than a few days. What the 1980 Convention requires is an assessment of the future risk, which we obviously agree with, whether or not they've already been run. Making that assessment, I have to look holistically at the mother's past prior to S's birth, her life with S to date, and the expert evidence. What we then get to is paragraph 53. And I think this is simply a mistake because there's a previous reference to 6 months. If the mother returns to Australia with S, she will have, for at least the first 3 months, they will be adequately housed. Well, as we've explored, it's 6 months, not 3 months. She will have enough money to live modestly. The mother will have access to medication, therapy and support to stay sober. So the first 3 weeks, she will have a live-in support of a family member. Now, the court will be aware from our skeleton that it had always been understood that the maternal grandmother would return with the mother, but at trial, it was suggested in submissions for the first time that in fact the grandmother was not available and that the grandfather, maternal grandfather, would be returning with the mother if ordered, and that he could only stay for 3 weeks. We note and we make the point that the maternal grandmother had spent the previous summer for 2 months in Australia shortly after S was born. But paragraph 53 sets out and encapsulates really all the protective measures which are being offered by the father. What the learned judge doesn't do in our submission is then evaluate whether in those circumstances the risk to S amounts to a grave risk and therefore satisfies the Article 13b threshold. Paragraph 54, the learned judge details the mother's current circumstances. She says it's highly foreseeable, if not likely, that all these symptoms will worsen once she and S are living on their own in Australia. Well, that's, we say, a somewhat strong way of indicating Dr. Ratnam's evidence, whose clear evidence was she's vulnerable to deterioration. What the learned judge then goes on to say is Dr. Ratnam's evidence was that neither optimal medication nor therapy will provide remission for as long as maintaining stresses persist. Well, we weren't suggesting that the mother would be in remission. We were suggesting, and Dr. Ratnam was making clear, that with optimized medication, there would be in fact a slight improvement and it would optimize her and mitigate against a further relapse or any relapse in her mental health. And so, again, that's a rather over-strong way of detailing and misquoting Dr. Ratnam's evidence in that paragraph. At the bottom of that paragraph, the continuum required to facilitate S's video contact with the father, which the mother already finds overwhelming, will be a recurrent trigger for anxiety, which she will have to manage. We don't disagree that there are going to be trigger aspects. We don't disagree that the mother has a history of anxiety, but we do take issue with the assessment that this amounts to a grave risk. Paragraph 55, alcohol dependence risk is small. Over the page. However, in my judgment, the greater grave risk, and again, we say that's a misuse of the term of art, is that the mother not coping with daily life to the point that she is unable to provide safe care. In getting to that, we, again repeat, forgive me, that the judge was wrong not to evaluate the mitigating circumstances, not to take on board the evidence of Dr. Ratnam and consider in all the circumstances, whether the protective measures ameliorated the risk, and if so, whether that risk still amounted to a grave risk.
If you look at that sentence, the greater grave risk is that of the mother not coping with daily life to the point that she is unable to provide safe care.
Yes.
And you've taken us through the doctor's evidence. What's your submission in respect of that sentence? That it's not supported by the evidence, or is or
It's not supported. It elevates the risk to a point which is not supported by the evidence of Dr. Ratnam, and it's the penultimate, the last paragraph in her report, but also emphasised in her oral evidence to the court, that she can't quantify the impact of the deterioration of the mother's mental health in relation to the care of the child.
I don't remember Dr. Rantham referring to unable to provide safe care. That's the judge's
That's the
expression?
judge's words. Yes. Dr. Ratnam, just for the avoidance of any doubt, we go back to page H349. It's not possible to predict the extent of impact on parenting. As stated above, depression can impact on the ability to emotionally and physically respond to a child consistently.
And that's different from safe care, because safe care to a non-family lawyer means physical safe care.
Yes.
You know, we'll leave the child alone.
Physical harm.
Yes.
Physical harm.
We'll just leave the child alone and the child will come to harm.
Indeed. And there's no evidence, we say, to support that assertion and that finding. The I know Julie's just pointing me to the transcript. Perhaps we can look at page 19. Internal page 19 at C. Yes. Question. Then finally, you say in terms at the end of your report, internal page 19, it's not possible to predict the extent or impact on parenting. That's the paragraph we just looked at. Now, yes, that's correct. Mental health at this juncture, your assessment, she's currently depressed, but there's no evidence at all that her current depressive episode has had any negative impact on the care of her child. And she replies, there is not. So again, going back to paragraph 56.
But it's it's because the judge goes on to say, unable to meet S's daily needs, whether physical, emotional, or social. And that's, I think in effect, having read your skeleton, you're challenging the whole of that paragraph and the judge's conclusions as being not supported by the evidence.
They're simply not supported by the expert evidence, and they're not supported by the mother's own evidence.
Looking at paragraph 50, the judge says at the end of paragraph 50, she's looked holistically at the mother's past prior to S's birth, her life with S to date, and the expert evidence. So what she's basing her conclusion on must come from one of those three things. In your submission, it doesn't come from any of those three things, as I understand it.
No.
Yeah.
Her past prior to S's birth, well, that's set out in her statement, but that wasn't relevant to the context of the Article 13B defence. Her life with S to date, well, of course, as we looked at re earlier, we look into the future, and we look into what's on the ground in concrete terms, to use the term of art, if and when the child returns to Australia. And so we say that neither the mother's own evidence or the expert evidence set out the risks which the learned judge was now seeking to quantify. And if we go further into paragraph 56, the learned judge then, we say, rather goes on a frolic of her own, because she then starts talking about separation of the young child. There was no evidence that that was contemplated, or indeed a possibility, or indeed a remote certainty, and that on return, the ameliorating aspects of the protective measures would mean that the child would always remain in the sole care, remain in the care of the mother in Australia. And so when the learned judge at the bottom of paragraph 56 says, for the mother, knowing that once in Australia she cannot leave with S, even if psychologically paralysed or overwhelmed, is likely to exacerbate her feelings of threat and anxiety and increase the risk of the child being placed in a situation of intolerability. It's simply not borne out by the evidence. And then respectfully at paragraph 57, the judge says the protective measures offered by the father are necessary but not sufficient to address the Article 13b risks. That's all well and good, but the learned judge did not set out in what way those protective measures fell short. And that, we say, with respect to the learned judge, is my Lord Justice Moylan's observations in Re A, that she's fallen between two stools. She hasn't carried out the evaluative process of determining what the risk is, how that risk can be ameliorated, and in light of the protective measures, whether that risk still exists, and if so, whether that now still remains or is at all a grave risk. And effectively, the learned judge then goes on, what would ameliorate those risks? In my judgment, the only measure that would effectively prevent S from experiencing psychological harm. Well, again, that's incorrect. It's the package, as I emphasised earlier, it's the package of support which is necessary. It's not just familial support of the grandmother or grandfather in Australia. And effectively, we say that that's a misapplication of the test. It effectively puts the test as a burden of proof on the mother that she is going to be psychologically disabled and therefore have an impact on the child. And we again go back to the requisite test set out by the Supreme Court in Re E. And so when the learned judge talks about grave risk, she's talking about the grave risk to the mother as almost effectively a standard of proof, i.e. the balance of probabilities, and not the requisite test for Article 13b.
Well, if you look at paragraph 57, that seems, so the previous paragraphs as well, seem to be based significantly on the passages in Dr. Ratnam's oral evidence that you took us to. And the judge was asking questions on pages 23 and 24 of the transcript, when Dr. Ratnam says, my concern would be if and when her mother, as that was what was thought at the time, leaves Australia, and she's in Australia without that support. And then Dr. Ratnam goes on to give evidence about her views on that. So I think that must be what the judge is basing this on, because I'm not sure it's referred to anywhere else in the evidence. In other words, I'm not sure Dr. Ratnam deals with that specific issue anywhere else other than in that part of her oral evidence. Right?
My Lord is right. That's absolutely correct. But we say, doesn't put into the context of Dr. Ratnam's report, or indeed the context in which she was given those answers. She was indicating, of course, there is a risk, but the learned judge fails to evaluate that risk. And as I again repeat, apologies, that doesn't come to a conclusion as to whether that risk meets the threshold of grave risk.
Well, perhaps it's whether and why is the threshold of grave risk.
Yes, well, if she was applying the discipline that you set out in Re A, we say that she probably should have asked herself, on the balance of probabilities, will the child be exposed to a grave risk of harm in light of the protective measures that are being put forward? But that discipline was never carried out, and that's where we say the learned judge fell short and fell between the two stools that Lord Justice Moylan refers to in Re A. And we also say that the consequence of that is rather to lower the bar, the high threshold, which 13b attracts, because of the use of the word grave and the word intolerability. My Lord referred at the beginning of my submission to tough, the expression tough. Well, nobody pretends that mothers who don't want to go back to the country of origin and are returned pursuant to the Hague Convention is a particularly nice exercise or experience. But this is a mother who, of course, has dual nationality, lived for over a decade in Australia, independently, resourcefully, and successfully. And in all those circumstances, we say that the proper order is for the court to make a return order. And we again also emphasise, as we have at page 32 of the electronic bundle, reference to other authorities. And of course, each case turns on its own facts. But paragraph 41, B12 of your hard bundles, we set out a number of examples where the level and
Sorry, say it again. Which where?
Paragraph 41, B12.
Yes.
We set out a number of examples of other reported cases where the detail and quality of deterioration in mental health was much more acute, resulted in admissions to hospital as an inpatient, and the evidence was much clearer in respect of the impact on the child. We say that this case doesn't attract the same level of concern that those cases do. That's important when one considers the high threshold required for an Article 13b defence. So, my Lords, you plainly read our skeleton argument. We rely on the background, we rely on our submissions, and we rely on the 4 grounds that we've set out in our skeleton argument, and we say that this appeal should be allowed in all those circumstances. We say that it's important, of course, also to consider that despite my learned friend's skeleton argument, which pointed to possible additional evidence in relation to the mother's mental health, none has been provided. The Lords will also note the further arguments in my learned friend's skeleton arguments about proportionality and Article 20 and Article 21, none of which was dealt with in the judgment, and I don't propose to respond to that. And of course, my learned friends didn't provide a respondent's notice in accordance with the rules, setting out the basis on which they sought to uphold the learned judge's decision in any other way. So I'll reserve any reply if those matters are pursued with any vigour by my learned friend. So unless I can assist you further, those are our submissions.
No, thank you very much. Yes, Ms. Gupta.
Your Lordship, yes, I, together with my learned juniors, Ms. Kamar, Ms. Campbell Brunton, represents the respondent mother, who of course is at the back of the court sitting next to her father, and in front of them is my instructing solicitor. So if we just turn quickly to E3 in the bundle, which is the first order by Lord Justice Moylan in this matter, granting permission to appeal. Of course, the skeleton submissions on behalf of the applicant appellant have not been replaced. It's the leave skeleton together with the final skeleton hasn't been replaced by a final skeleton submission.
Yes.
We respectfully submit that, yes, of course, this has met the criteria for a sufficient prospect of success and sufficient issues as decided by Your Lordship. But at the same time, Your Lordship ordered one, we say, very important piece of information and evidence, which is the transcripts of the evidence of Dr. Randall. And we say that looking at the judgment as a whole and the transcripts of evidence, the court below was perfectly entitled to make the findings and the decision that the learned judge in the court below made. Had this learned judge been a full-time family division judge, maybe she would have added more detail, more process to her decision. But bearing in mind what was actually said, and of course it's been accepted by Moylan and friends in their skeleton submission, paragraph 31, that the judge correctly directed herself to the relevant law. So she directed herself correctly. The question is, did she apply it correctly? That's the key issue here. My submission, obviously, is that she did. And if we look at back to that passage of paragraph 34 of Re E in the authorities bundle, that's page 95 of the authorities bundle.
Sorry, I missed the page number.
Sorry, page 95, authorities bundle. And if you need reminding, previous page actually, of course, the top has Article 13b set out, which, despite one being involved in these kind of cases more often than not on this side of the bar, I keep on having to refer to that, going back to actually what the convention actually said, because we respectfully submit that you can't add gloss to it. But I'd ask the court to bear in mind paragraph 34. And we all know this passage. Intolerable is a strong word. It's 3 lines down. When applied to a child, must be in a situation which this particular child, in these particular circumstances, should not be expected to tolerate. That's from Re D, Baroness Hale. Of course, she's quoting herself there. And then those words were carefully considered and can be applied to just as sensibly to physical or psychological harm as to any other situation. Every child has to put up with a certain amount of rough and tumble, discomfort and distress. It is part of growing up. But there are some things which it is not reasonable to expect a child to tolerate. Among these, of course, are physical, psychological abuse, neglect, etc. That word reasonable in my submission is something that needs to be highlighted. And if you stand back for a moment, if the court finds that there is a grave risk that the mother will have a relapse or that her mental health will deteriorate, will it be reasonable for this child to be placed in that situation of having a mother in that condition, or is it actually intolerable? Is it intolerable for the child? It's not expected to tolerate that. This is, of course, effectively a babe in arms. She's always been in her mother's care. And as the learned judge pointed out in her judgment, she's only been in her mother's care alone in Australia for a few weeks at a time on 2 different occasions.
Your submission there is that if the court finds that the grave risk mother will have a relapse or deterioration of her mental health, does it depend on the nature and extent of the relapse or mental health? In other words, you've got to look at, it's not just that there is a relapse or a deterioration.
It has to be grave.
Yes. It has to be such as to amount to a grave risk.
Indeed.
But it's got to impact on the child as well. There's 2 stages, if you like.
Yes.
What is the likelihood of there being a relapse or deterioration, and indeed to what extent is there going to be a relapse or a deterioration, because it's not a binary situation, and then to what extent is that going to impact on the child? You said expose the child to that situation, i.e. to the situation of the mother having a relapse, but you need to know whether or not, don't you, that what's going to happen to the child in terms of care, love, affection, whether that's going to be...
Well, indeed, but with great respect, Your Lordship, I go back to that wording. There are some things which it's not reasonable to expect a child to tolerate. Yes.
That is because of the potential impact on the child. It's not just in abstract.
It's not in abstract, no. And obviously one has to have a, wanting a better word, and it's used a lot, holistic approach to what is likely to happen concerning the mother, bearing in mind the history in this particular case, mother's own mental health history. And a key factor, which I respectfully submitted in the court below, which is the birth of a child, because of course mother's mental health was managed in the past before she gave birth, and then we respectfully submit that was an important factor in her inability to see beyond her difficulties, if I can put it that way.
The evidence of that it was the child, the birth that.
Well, we respectfully submit that she
As long as
obviously
having a
managed
child
her
is
mental
going
health.
to have a major
before.
impact on any person, any
Yes.
mother or father.
Well, indeed.
But where's the suggestion that this added burden or this added responsibility?
Well, we would respect to the actions of the mother to go back to her own family in England. This is not a case of going back to mothers. This is a case of a woman who can't cope psychologically because of her background, because of her vulnerability, and realised that she's, and here's a word that I'd ask the court to bear in mind, page 9 of the transcript of Dr. Ratnam's evidence. Paragraph E, at the bottom of that E, section E, where the expert says, now with that support, that practical day-to-day support, this is obviously in England, of a mother with still a young baby, with this mother's psychiatric history, there's a significant risk of deterioration if she has to go back to Australia. Leave that network isn't there. And the answer is, in my clinical opinion, there is.
Yeah, but you've got to read the next two sentences as well, because the judge didn't hear and said, could you repeat that answer? And the answer was yes, in my clinical opinion, there is a risk of deterioration. The answer leaves out significant second time round, oddly enough.
Because there was a lot of leading questions, weren't there,
Yes, indeed.
throughout the examination.
Indeed, there were.
Chief,
Yes,
both always adopted.
yes. But in my submission, the word significant comes up again and again. And if you look at the large section in answer to the learned judge's questions, this is at page 23, moving on to 24.
Yes.
I want to read it in context. We know that individuals with inaudible episodes of depression with vulnerability, the risks of relapse can be between, and then it says, a high percentage, 70 to 90% of depression. So there's a significant risk of deterioration or relapse. And my submission is that the word significant can be equated with grave. Grave. Significant risk and grave risk, and this is why the learned judge, the learned trial judge, in her decision, eventually, in her judgment, of course, moves on at paragraph 56. I also consider that there's a grave risk of the mother's mental health deteriorating to the point that she experiences a crisis. The word grave, of course, comes up in the
That's quite a
treaty,
significant.
convention.
That's quite a significant submission that you say that. Sorry, I keep using the word significant.
Yes.
That significant can be equated with grave. I'm not sure I understand that.
In my position, in this case, this is what the learned judge did, and she was entitled to do so. But if we look at the word significant, and you mentioned the word, Your Lordship, threshold earlier on, and of course, I immediately started thinking about public law cases. Significant harm is the threshold criteria, isn't it? We don't have the word grave really in our domestic Children Act legislation, but this is a word that's from the treaty. It is a high standard, but it is in the circumstances of this case, the leap from the word significant, as set out, significant risk, as set out by the expert, yes, after some initial questioning, leading questions, then she went on to develop that and explain that why she felt that there was that significant risk, meets the criteria in this particular case of grave risk.
Because of what? I mean, sorry to press you on this, because it would have to be connected to the nature of the deterioration and relapse.
Yes.
Because deterioration is a broad word, relapse is perhaps more specific, but it's not saying how and what. The judge extrapolates and says experiences a crisis, experiences a collapse, unable.
Yes.
But the doctor doesn't say that. She just says this is a significant risk of, and I'm going to incorporate or add the word, a deterioration or a relapse.
Yes. And by relapse, one assumes it's the alcoholism that she's talking about. That's the assumption that I made, but could be wrong. But deterioration is psychological.
I'm not.
sure that you can say that,
Yes,
here,
yes.
actually. Because she doesn't say that. She's talking about depression and relapse in the context of depression.
Either way, with great respect, we say the learned judge, when came to her judgment, was entitled to draw her conclusions from that evidence.
The other difficulty that I've got is that 55 and 56 of the judgment deal with different things. 56 deals with grave crisis and 55 deals with something else. But if you look at what the evidence was at page 24, you're looking at, yes, there is this risk, significant risk of deterioration, relapse. And the next question, not being a family lawyer, that I would ask is, how will that impact on the child? And what this page 24 appears to be talking about is that although the mother's always coped and loved the child so far, there's a risk of her becoming emotional and not being able consistently to respond, which will affect the child's attachment.
Yes.
And then she goes on about having a mum who's not always emotionally available or emotionally distressed, which could impact on her own well-being. I don't see a reference to affecting the physical safety of the child. I don't see a reference to grave crisis there.
But is it reasonable to expect this child at this age to tolerate that
what?
significant risk of deterioration or relapse? Well, I'd respect to submit it's not.
But again, it is the impact on the child, isn't it?
It is indeed, yes. And this particular child of this age, who's only known the care of her mother, and who's being, the application is for the mother to return with the child. There's no one else. Father can't come over for his own immigration reasons. We haven't had any further information about that. So it involves mother returning. She's not saying she won't return. It's not one of those
Yeah, but the
cases.
starting point is she
Yes.
shouldn't have taken the child away. She should have left the child there. And the question is now, should the child be returned so the Australian courts can deal with it? And the question is yes, unless a very high threshold
Absolutely.
is passed.
Yes,
And that high threshold does require us looking at, however you phrase it, the likelihood of the risk materialising,
yes.
and then what the consequences of the risk materialising would be.
In the context, of course, that this is an appeal.
I
And
accept that.
indeed, and we respectfully submit that it doesn't surmount the test for a successful appeal. As I said, yes, it could be further explained in her methodology, but she clearly set out in her judgment the correct test, and then she, within her judgment, uses phrases, as your lordships have pointed out, that of course come from some of the authorities that have been cited.
Ultimately, it's got to be based on the evidence, isn't it?
It has to be based on the evidence, but in Morriswick's submission, there are certain conclusions that a trial judge can make as to what the likelihood is on the balance of probabilities in a certain circumstance. And in circumstances where this learned judge, in her analysis, explains how it is, paragraph 53, what the circumstances on the ground would potentially be for this this child, if I put it that way, with her mother.
What do you say
And then-
about the point that has been made, Garment, even though that sets it out, it doesn't grapple, as it were, or seek to assess why it may not be sufficient.
Well, because the overarching issue, as far as this judge is concerned in Morriswick's submission, is the lack of a presence of family members. Paragraph, sorry?
Other you mean, or
The mother's family members, indeed. What was said, for example, in the written submissions on behalf of the appellant was that the mother has friends support in Australia. But if the court turns back to the report that was put to the expert in
I think two of
cross-examination,
those have,
this is,
two would have remarried or whatever.
yes, indeed, H335 is the reference. She's a lot of support in England apart from her sponsor, including her mother, her sisters, her father, Jackie, aunts, uncles and home group. She has two close friends in Australia, Lucy and Kay, but Kay has moved, has her own family. She also has a friend from AA, but her friend moved, and as has her, I assume, her sponsor in Australia. So we are talking about somebody in real terms on the ground within 3 weeks of return after my client's father has left, will be isolated. And that's why we respect to submit that the learned judge was quite right to be concerned to the extent that she was about the real situation on the ground. The likely scenario of family members not being there and having that effect on her, and the nexus, I think this is the question really, isn't it? The nexus of that and the effect on the child. Is that something the child should be expected to tolerate?
But that's the question. If there is a real impact on the physical, emotional, or social well-being of the child, it's easy to say no child should be able to be required to put up with that. But that's not quite what you're saying. You're saying the child shouldn't be expected to tolerate the relapse in the mother. But the question is, if that relapse affects her ability to function adequately as a mother.
Yes. And of course, it has to be said, as we mentioned in our written submission, that we might be producing further information. We haven't done so. My client is not trying to be histrionic about this. She has, of course, produced all of her medical records in the past, and that is something that weighs not against her in her ability to basically look after herself in the past and provide good enough care, physical, emotional, other care for her child. That shouldn't be counted against her, but rather for her, that in different difficult, distressing circumstances, as she's had in the past, she's still been able to look after her child. But unfortunately, there are situations where this lady herself, of course, has had suicide ideation, etc., and attempts, it seems, prior, long before the birth of her child. And that is why Dr. Ratman, in her evidence, if I can just turn back to that, explained that fully when she came back to her, she provided a sort of context of why she felt that there was a grave risk, significant risk of there being a deterioration in her this lady's psychiatric and psychological condition. If we go back to, for example, page 16 at the top of the transcript, positive indicators are the, top of page 16.
Yes.
Positive indicators are. So it doesn't necessarily point to a diagnosis of depression or prognosis regarding but it's positive that she has an awareness of the effect on the child of the emotional distress of the mother. So these are positives, but when it comes down to it, despite her best efforts, Tomorrow's submission, the expert identified the risk as significant, and that meets, in this particular case, the way the judge built on that, and we respect to admit she was correct to build on the evidence in a likely scenario way, balance of probabilities way, to build on that and say, well, this really does amount to a grave risk that I can't ignore and meets the criteria. the if I can just turn the court to the questions of the learned judge, because of course she drilled down as much as she could, and what was actually concerning her, page 20 onwards, is really essentially the learned judge cross-examining the expert about what was particularly troubling her. And I'd ask the court to read through that in its consideration of where the learned judge ended up in her consideration and her deliberations and her decision. For example, page 22. And learned judge trying to drill down. And so, do you think that a return to Australia would impact adversely? What do you mean exactly? So I think there would be further deterioration of Miss Renshaw's mental health should she return to Australia. I mean, it doesn't seem to be likely or probable. She just says there will be, or there would be. I don't know if it's possible that augmenting her, while increasing her dose of medication, augmenting it will help. Cannot predict the percent that. The alternative situation will be challenging for her, likely to further impact upon her mental health. And of course, the passage, which needs to be read very carefully in our situation at the bottom of the following page. Again, learned judge asking a lengthy question. Can you tell me a little bit more about the future as you see it for the child, if the mother was asked to return with the child to Australia? So the learned judge is correctly asking about the child. She's not just simply saying, well, they come kit and caboodle at the same thing. And there's a very lengthy response there, which I'm just going to read in due course in detail, and in detail, because I can't cherry pick that. It has to, of course, all be read together, the whole of the evidence, with all the leading questions, which we apologise for, but there it is. This expert has given much evidence over the years in Hague Convention cases, which you'll have read when I first started asking her questions. And page 3, for example, I asked this expert.
Sorry, page 3 of the
page
transcript.
3 of the transcript. I beg your
Yeah,
pardon, at the bottom.
Yeah. Yes.
Would you agree that she's highly vulnerable? This is at the bottom. And there's that word significantly again. She says that effectively my terminology. And then she explains it.
Significantly vulnerable, less vulnerable than highly vulnerable. Sounds as if she's bringing it down a notch from where you suggested it was. How it helps us, I don't know.
Well, I say it's the opposite, Your Lordship, but there we have it. Because if we say, as I said, if we import that word into common parlance in the Children Act, where you say significant harm, that is grave harm to meet the threshold criteria. But that's a different significant. That's just to show the court how she saw that word. But then she explains it in the next passage. So I would say that I have significant expertise in the mental health of women. By that, one sees, it looks like she's saying she has a great high degree of it. This is at the bottom of page 3.
Yes.
That's how she uses the word significant there. I mean, the majority of my medical legal work tends to be with mothers. I'd say I have significant expertise in the mental health of women. Population of parents who I've seen, I can compare with Miss Renshaw, mother against. Given her history, longitudinal nature of mental health, I would say she's significantly vulnerable. She explains that. And if you want context, Your Lordship, Lord Justice Lewis with regards to how she's using the word significant. There you have it. And at the bottom of page 4, this is one of the reasons why I think both sides were very happy that this expert became available at short notice, which is this expert has had a lot of experience in Hague Convention cases specifically. And she says, sorry, so what particularly strikes me in some Hague Convention cases, the medical records referring to difficulties with mental health, which starts at the onset of the proceedings, whereas hers really predate these proceedings, there's the word again, significantly.
Yeah, I mean, by a long period of time.
Yes. Well, what I'm respectfully submitting is that the use of this word by this expert means to a very high degree. That's when she's describing her own expertise. That's when she's describing my client's long history. And there she explains the context in which she's placing, her professional context, in which she's placing her conclusions. And there's the word again at the bottom of page 5. She reports she's getting significant practical support, particularly from her mother, day-to-day activities. It's a high level. And Margaret's motion was asked earlier on about by Lord Justice Baker about the mother, the learned judge saying the mother wasn't able to get out of the home. That's not actually what the learned judge said. I think it was paragraph 52 of the judgment, where she says, at the bottom of explaining what the day-to-day life is of the mother, but she's able to do very little with S outside her home on her own. Just enough confidence, motivation, energy to take her out for a couple of hours once a week, just the two of them. And she's done that based on the evidence, which you'll find at H130 in the trial bundle. So the Morris position of the learned judge wasn't wrong on fact, which was claimed in any event, wasn't wrong on the law. And when you dig into the transcripts and you see that the questions that she herself put to the expert, she was correct in saying that the risk of deterioration and relapse in this mother was high, and bearing in mind the mother's day-to-day care, historic day-to-day care of the child, the fact that she's going to have to return with the child if ordered, so she can't stop herself from being exposed to that environment on return, that the intolerability is there for this very young child. And that's something that I'd ask the court to bear in mind. The age of this child, 16 months old. Lord Justice Henderson, Re P, paragraph 61 of Re P.
Hold on.
Which is page 142 of the authorities bundle.
Concrete term.
Concrete terms, indeed. And no amount of finances and arrangements, practical arrangements, we also submit, could assist in the situation the way the learned judge decided they couldn't when she came to paragraph 56 of her judgment, knowing and having started with, as Lord Justice Lewis said, the beginning of the Hague case, which is why should this child not be returned? And only in rare cases is a Article 13B case made out. One size, however, doesn't fit all. And it is correct to say in my submission, of course, that this is not within a sort of conventional reading format. But I hasten to add that, of course, Dr. Ratnam, in her conclusions of her report, confirmed H346, paragraph 2, diagnosable, recognised psychiatric or psychological condition or disorder. And she refers one to the previous answer where she explains the history effectively. But at the end she says, in addition, the mother fulfills the criteria for a diagnosis of post-traumatic stress disorder with nightmares, flashbacks of trauma in the relationship with the father. However, in order for the diagnosis to be made, the trauma has to have occurred. And of course, there's no findings in relation to that. But that brings us back to really the subjective approach and the anxieties that you've, of course, read about. There is, of course, there's other aspects of our skeleton submissions, which just is something that came up. I entirely take on board what Moylan said about the respondent's notice. And it may be that this court feels that this particular case, there's no need to pass any comment in relation to this particular aspect of our skeleton submissions. But if you look at a paragraph 51 onwards
Sorry,
of the skeleton submissions,
sorry, yeah.
which in the bundle,
This is on proportionality.
this is on proportionality.
Does it add anything to the overall?
Well, arguably not, no, but it's something, it is arguably not, because it is something that the court has to really think about in all cases.
In this particular case?
In this particular case, there is an aspect, an interchange that took place right at the end of the proceedings during counsel being asked by another judge, what would happen if, and what would happen if the mother goes back and she applies for permission to relocate? And the answer was, would the father oppose it? I don't know. And so then one enters into the world, especially in a scenario where the father hasn't actually made, it seems, any attempts to renew an application, immigration application, to come and see his child, of what is this all about? Of course, one is in a situation, in Hague cases, of the applicant getting non-means, non-merits, automatic tested legal aid. So unlike the respondents, all he has to do is fill in the form and away we go. But we would ask that the court just bears that proportionality aspect.
So I'm not following this. I don't understand how the last two matters affect what we are deciding. The father can't come to this country because he's got a criminal record, and it's a matter for the Secretary of State for the Home Department, and he's decided he shouldn't be allowed to come in. There's nothing we can do to change that. The next question you referred to, whether the father getting automatic legal aid in a Hague Convention case, I don't understand how that's relevant to the proportionality of the exercise that we are dealing with.
Well, the first point was simply that the father hasn't renewed any application
For what?
to come and visit the child.
He can't.
Well, he
He's
can
not going
make
to get
it.
a visa.
Well, that was the first attempt that my client
Criminal
made.
record is not going to change.
Maybe not, because that was the first attempt my client made
And
without
maybe not.
knowing
The
about
criminal
his
record
background.
can't change. And why would the Home Office take a different view, given the criminal record?
Well, because appeals are made to the Home Office, often different circumstances put forward, and if the child's remaining in this country, then of course the father could say, I haven't seen the child for a long time, and here is my full application, and here's the sponsors that I have, etc. My client's offered that. But this is simply an application for, and here's the point, summary return of the child. That's the whole basis of the Hague Convention case, and we respect submit it's inapposite in this particular case, that it's disproportionate response. One could say, of course, this country is treaty bound to approach it that
I
way.
don't understand the proportionality here. We are treaty bound.
Yes.
The mother should not have removed the child. And the question now is whether or not the circumstances in Article 13b are made out. If they are made out, the child will stay here. If they're not made out, the child should be returned, and then Australia would decide the welfare. I'm having trouble with the proportionality.
Yeah, well, maybe I can help you with that trouble in that it doesn't help my case, but the end part of our skeleton submissions,
Mm.
we cite G and G from the Supreme Court, and the quotation there is the application of Article 13b ensures that the court is not acting in a way which is incompatible to the ECHR. The 1980 Hague Convention proceedings are focused upon the child, but that focus itself involves considerations of the position of the taking parent. Article 20 is not to be used as a way round the rigours or other exceptions of the return of the child.
It's
I mean,
built in. Sorry.
Yes, it's built.
No, I mean, I must admit, I thought these paragraphs had a different target audience than us, because I don't really see how, as others have said, how proportionality,
Yes,
either Article 13b is made out or it isn't.
yes.
And I
Well,
don't
you
think.
have my submissions.
Yes,
Yes.
yes.
Thank you very much. Can I just turn my back for a moment?
Certainly, thank you.
Yes, in answer to Your Lordship, Lord Justice Lewis's question about where is the evidence with regards to this particular birth that it caused difficulties for this mother, there is of course pre and postnatal depression,
Oh,
medication,
which is diagnosed.
which is set out in the medical evidence, and my client's own written evidence. So I'm grateful to juniors for that.
Yes.
Can I assist Your
Yes,
Lordship?
one
any further?
further matter. Mr. Jarman, if we decide that the judge's decision is not sustainable, he invites us to determine the application and obviously invites us to make a return order. Alternatively, we don't feel ourselves in a position to make that to remit it, but his primary submission is that we should make a return order. What's your submission in the event that we consider the judge's judgment is flawed and her decision is unsustainable?
For the matter to be remitted to the court below for a fuller inquiry with less leading questions of the expert. And
I don't think I'd be so.
Wouldn't take it too personally. It's
I wouldn't
certainly
take it. I mean, it's nobody's expert. I don't think.
Yes.
You know, you're entitled to ask.
trouble is when they don't actually come up with the reply that you're suggesting to, doesn't it?
yes,
But anyway, your submission is that, but to expand on that, is that that we're not in a position to substitute our own decision, that a further fuller inquiry would be required.
indeed.
But why is that? Because there was the prospect of further evidence, and there hasn't been any further evidence. So there's never going to be, is there, any more evidence than we've currently got?
Well, there would be further expert evidence drilling down on the issues that this court could identify, of course. What is the grave risk, if one does exist, etc. And it is a movable feast, as the court well knows, mental health. I don't know how my client will be responding in any event to a decision that the appeal is allowed. And that the best place for that updated information is the court below.
Thank you. Anything else? Anything else? No. Yes, Mr. Chairman.
Just on that point, of course, on Monday is the 2nd of December, and that will be a year since this child's been in this jurisdiction. So we do invite my lords to, if you consider the judgment can't be upheld, we invite to make a return order in those circumstances, 12 months after the wrongful removal of the child to England and Wales. it's right also to emphasise that Moylan and friends trailed in their skeleton argument the possibility of further evidence. That wasn't pursued, it wasn't produced. And you have the available evidence. That report of Dr. Ratnam is in fact only just now 3 months old. And so without any significant change, without any further evidence relied upon, you are armed with all the available information in which it's possible to make an order. Well, very briefly in relation to Moylan and friends submissions, significant is not a word that appears in Dr. Ratnam's report, written report anywhere. In relation to the support that Dr. Ratnam was anticipating or emphasising, if we look at the transcript of her oral evidence at page 18, my questions...
Sorry, hold on. Yes.
My question at the top of the page, your professional opinion would be very important aspects and needed, or almost a requirement to help support the mother socially and mentally. She replies yes, and then she starts, sorry, I was just going to say that if her mother could go with her and ideally remain, I don't know how long visas are granted for in Australia, but if she could remain there for a few months, then that would really be supportive for the mother. And so, despite my rather clumsy way of putting the question that there was a requirement, the expert Dr. Ratnam was saying, well, that would be the ideal. And so in terms of
Is it reasonable? I mean, grandmother will have her own responsibilities, her own family life. She's got at least one other grandchild.
yes,
And if she
Well-
says, I can't go, or I can't go for more than 2 or 3 weeks,
my lord, we say that that's a matter for the maternal family. The maternal family have never said nobody will go. It was always understood, as I indicated earlier, it was always understood the maternal grandmother would go.
somebody would go for 2 to 3
But
weeks.
somebody will go. We say that in the likelihood is the maternal grandmother probably will go and she's able to stay for longer. But the reality is that both are retired, but that's a matter for them. And in light of their knowledge of their daughter, in light of their knowledge of the issues, they will support, I'm sure, as my lords can be sure, they will support their daughter to the best of their ability. And in previous years, that's meant a time of almost 2 months. In terms of concrete evidence, concrete grounds upon which this mother's returning, as my learned friend indicated in repeat, we say that the father's case on return is very clear. Properly protected, proper maintenance, proper accommodation, fully accessible to medical, professional, mental health resources, and AA in the past that she's always used. It couldn't be clearer and it couldn't be more detailed. And finally, in relation to proportionality, I don't think my lords are going to be very concerned about it, but of course this is the father's application pursuant to the 1980 Hague Convention. Nothing more, nothing less. He simply seeks the return of his child to Australia. Lords, unless there's anything I can assist you further with.
No, thank you very much. Well, thank you all very much for your comprehensive submissions. We are going to reserve our judgments. They will be provided to you in draft as soon as possible. I can't tell you exactly when. I understand, obviously, we understand, obviously, the emotional context of the case and the pressure that exists from it being, or the appeal being unresolved. And so we will do our best to do it as soon as possible. And once you receive it, we would hope you will be able to agree a draft order. But if not, we'll deal with any outstanding matters on paper. So thank you again for your submissions.
All those in favour?
Right, coffee shop.